Yes.
Yeah, this is it. Lordship, I may be allowed to mention hearing item number 3536.
35-36.
This matter cannot be.
I am disabled. I am disabled from taking up this matter.
Yes, Lordship.
35-36. Listed before the appropriate bench without me. Lord.
Like,
Yes.
Lordship, please allow me to mention hearing item 37 to 39. The main counsel, his friend, is out of station and he will take up the hearing. It may be kindly set after 2 weeks.
Yes. Okay. You are the counsel for the
I will counsel for petitioner.
petition. Mr. So-and-so. The learned counsel for the petitioner. 6 for 2 weeks adjournment. Stop. Prayer is allowed. listed after 2 weeks. Okay.
May it please lordship.
Yes.
My lord, in this case, we have filed a caveat. But then the caveat number has not been shown, nor a petition has been served to us till date. So my lord, with the consent of the London Council for the petitioners, if the matter can be come up after the ensuing summer break, since the council for the petition is also going on break.
Your
My lord,
lordship, just got the information that there is a caveat,
Uh,
but
the caveat is here.
yes,
It's not listed.
but
It is not shown in the course list.
yes, your lordship. And in fact, my learned friend was telling that they have sent through a registered post, but it has not been reached to us till date. But anyway, your lordship, actually matter is also because this committee is for 20 to 24 and only a few months left.
If it is for 24, then the whole year is there.
23.
23, 24.
24. So your lordship,
So you are not actually submitting on behalf in the interest of your client.
yes, your lordship, I am submitting on behalf of my interest of my client, your lordship. That the matter may be taken expeditiously. Actually, your lordship, I am the Kukami Hoho. And
You are both. You are both.
your lordship, that my contention is that Kukami Hoho is having their constitution, as well as Western Sumi Hoho is also having their constitution. But Western Sumi Hoho is interfering into the matter of the Kukamis Hoho, who are having their registered constitution duly approved.
Why don't you expedite the trial before the learned trial court
Now your
and
lordship,
let the trial court scrutinize your claims on the basis of the constitution?
your lordship, here taking the advantage of this order passed by the court below, principal district and session judge, they have already entered into the office. Those who are selected by Western Sumi Hoho. And we the Kukamis who are selected by our office bearers are selected as per our constitution, Article 7. We are selected.
So that's why I'm saying instead of keeping the matter lingering, why don't you actually contest the case before the trial court and dispose of? And see who is the right office bearers as per the constitution of Kukami Hoho?
Perhaps, my lord, the trial is about to commence. We have written, given our WS on the last two occasions.
So WS is also filed then.
But in the meantime, they have already entered into the office, your lordship, taking the advantage of this order.
No, you have also taken the advantage of the order passed by the civil judge.
But it was within the purview of constitution, your lordship. Constitution of the, now legality and propriety of this order passed by the learned district and session judge is to be taken into
My lord,
consideration.
at this stage, we are yet to receive a petition of the civil appeal also.
We will list it again on Monday. Showing the
Lord,
caveat in the cause list.
My lord, the leading counsel in this case is out of session. The leading counsel, Sir M.T. Longjan, went to his hometown for attending his.
It's all right, it's all
father's
right. Without even the leading counsel, we can just list it again on 26/6/20. Yes, 26/6/2023. along with caveat number 6 of 2023. Okay.
Much.
Obliged.
Yes. None appears for the applicant, listed after a week.
One of the main rate petitions that have been put is honorable court. That is WPC number 38, 2021. Then this honorable court passed stay order on 25/8, 2022. The operative part is page 18. My lord. In that view of the matter, till disposal of the retribution later such as such, these are approval order and the appointment orders. Then what happened is that.
But nothing is clearly reflected here.
To-
Yeah, Mr., are you appearing for the respondents?
Yes.
What is your submission?
Lordship. The petitioner's case is under consideration by the BNR.
Uh, No, the issue raised by the petitioner that in spite of the stay, you are allowing the petitioner to continue. There's a stay order. There's a stay order, and as per the RTI obtained by the petitioner, it seems that the petitioners are still allowed to continue. Respondents, sorry, the respondents are still allowed.
Unless occasion, last order, your lordship see, kindly see. I was directed to see how the Department of BNR is proceeding.
Last order,
That's in the.
This is the
mandate
first time.
petition.
Yes, last order.
no, this is the first time which is listed. Are you aware about the case?
I know.
Contempt,
This is contempt.
contempt,
So.
Oh.
Yes.
this is contempt.
Lordship, we are trying, but
No, no, no. Are you consciously standing to represent this case?
I know the case, but if my learned senior friend is proceeding for the contempt, then I have nothing to say.
Have you been engaged to represent the respondents in this contempt?
No.
You're actually representing in the main writ petition,
My lord.
in the main writ.
I was in the main.
So whether the respondents are allowed to continue in spite of the stay order.
Notice patient, your lordship, notice patient. Notice patient.
We will. That is the duty of the court. But I'm just asking you, since you are the counsel in the main writ petition. I am just asking you whether the respondents are still allowed to continue in service in spite of the stay order passed by this court. Which is that order?
That's from page 8, my lord.
Okay. Okay. Heard Mr. M.T. Longchar, the learned counsel for the petitioner. Stop. The present contempt petition has been filed. For violation of the order dated 25/8/2022 passed by this court in WPC 38/2021. Stop. The operative portion of the order dated 25/8/2022 reads as under. Maybe. In that view, till remains state. Okay. It is the case of the petitioner that despite the order dated 25/8/2022 passed by this court, the respondents are allowed to continue in service in violation of the stay order granted by this court, right, order dated 25/8/2022. Issue notice to the respondents, returnable within 4 weeks. Stop. The learned counsel for the petitioner shall take steps for service of notice upon the respondents by a registered post with AD within a period of
2 days.
3 days from today, listed up to 4 weeks. Okay.
Much obliged.
Lordship. Hello, my sincere apology, Lordship. I was caught up in the traffic. I could not reach in time. Item number 2. Lordship, if this can take up the part 1 item, Lordship, special request, Lordship.
Why?
Because I was stuck in the traffic, Lordship. I could not reach in time. My sincere apology, Lordship. The city has been called, Lordship. I have requested a procedural also, Lordship.
Okay, we'll take up next week.
Lordship, my apology, Lordship.
We'll take up the bail hearing next week.
Lordship, the
next week.
city has been called, Lordship. If they can.
The CD has been called, okay, maybe, but we'll take up the hearing next week. Your case is under POXO.
Lordship, yes, Lordship, I'll
So,
satisfy, Lordship.
we'll take up next week.
Lordship, I'll satisfy your Lordship.
Next week, we have list fixed on next week. Yes, yes, next.
Item number 4, item number 4 and 5.
IA is for condemnation of 13 years, 2 months.
13 years.
Malo. In filing the writ petition. One of the reason I have given here. What happened is that the petitioner was discharged with 1 certificate only. So what happened?
Your discharge is not relevant. What is relevant is the delay. 13 years. Where have you explained?
Malo.
Where have you explained?
In my affidavit in reply,
Affidavit in reply?
Malo.
This is your petition. IA is your petition.
Yes, Malo.
In your petition, where have you stated about the delay?
Malo,
13 years, 2 months.
the reason was that the petitioner was not given any documents, number 1. He was discharged only with a discharge certificate. So what happened is that the petitioner applied for RTI for the documents. Then appeal also was filed, but it was not furnished. So what happened? Leading with no alternative, which want to impute, we filed WPC 188, 2018. That is my annexure to, in the reply affidavit, annexure 5. When we filed the writ petition, we include only the discharge certificate in the RTA application. Then
When were you discharged from service? Discharge already, 2008 you were discharged,
Malo,
correct?
Malo,
And only in the year 2017 you file RTI.
Malo.
How do you explain the
Malo.
intervening period?
There is an instance. The petitioner, he having no legal knowledge, without any documents,
That is no good.
nobody can give him advice. It was only in the year 2017. One of his friends from the same battalion informed him that actually he gave my name directly to the petitioner. So he contacted me. So
Mr.
when I call up, Malo, I asked specifically whether any proceeding or any order has been issued. He says that nothing was issued. So the whole proceeding was without any evidence or documents. So we applied for the RDI. Then what happened is that he didn't furnish that to the petitioner. Then when we filed the WPC 1,
That is the sequence of events after 2017. That is the sequence of events after 2017. What about the delay from 2008, January 2008 till June 2017?
my lord, that is what I'm saying.
Where have you explained?
I may be allowed to take your lordship to my affidavit in reply. Para 2:1. At the time of discharge, the petitioner was not furnished with any documents except discharge certificate, my lord. It was a unique writ petition before your lordship.
It is not unique. It is not unique.
Discharge certificate was the only impugned order.
So you said over that the discharge order for almost 8-9 years.
My lord, what I'm trying to say is that had the petitioner been given as per the rule, the statutory documents, the rule is clear. If somebody has to be discharged, there should be a proceeding. In the
We are not on that.
material have to be furnished to the petitioner.
We are not on that. We are not on that.
So what I'm saying is that without any documents, the petitioner did not know how he was discharged.
You were at least served that discharge order,
Discharge certificate,
discharge certificate. You could have taken steps.
order was not given.
No, you were at least served with the discharge certificate.
My lord,
So you could have taken steps on the basis of that certificate.
my lord.
And you said over there for almost 8, 9 years and you're coming with that ground now.
It's more than 11 years, Lordship. From 2008 to
My lord.
2017, more than 11 years. And he was sleeping for 11 years.
I think although the court should be liberal in condoning the delay, I think 13 years, I think this is too much.
13 years is because of he producing the document after I filed a writ petition in 188. I have to withdraw the petition because those documents,
When did you file the 188? Which year?
Two 2018, my lord.
2018.
My lord.
I was on you. Why actually like between the 2000?
But there is annexure 5 to my affidavit in reply. File on 1/10/2018.
Okay, from 2008, 2018, okay. 2018, we say, okay, you have filed your case. Actually, you, because of the documents filed by the respondents, you had to withdraw and then you have to file a fresh writ petition.
My lord.
Let us assume that. Let us assume that. But what about from the year 2008, January 2008 till June 2017?
My lord, that is what I stated. It was only in the beginning of June 2017, the petitioner was made to understand by one of his friends, namely.
No.
Commodore Sergeant.
I think that should not be agreed.
My
You
lord.
were made to understand 2017. Okay, we'll pass the order.
My lord,
Okay,
one thing is that
keep it. We'll pass the order in the chamber. Yes, we'll take all your submissions into consideration. Yes.
much pleasure.
Yes, what is 6?
Well, the last time on learner frame was directed to produce discharge certificate of the deceased, the petitioner's husband.
Yes, who is for the government? Mr. V. Jimomi,
Yeah.
No, Lordship.
you were supposed to come with necessary instructions.
Yes, Lordship.
What is the case about?
Uh,
What is the case about?
The case is about the petitioner husband who was working at the workyard. He died in harness. But till date, the disease release order is not issued.
The,
Disease release order.
release order of the deceased.
Lordship, I have instruction, Lordship, let it come up, part heard.
No,
First part, Lordship. Since
why?
right now I have hearing matter for number 1.
Okay.
After the listed matter,
Hearing matter. You have hearing matters
Lordship.
listed on Monday.
Much obliged.
This is Lordship.
Yes.
Your Lordship, I'm appearing on behalf of Mr. M. Kumar, counsel for the petitioner. Your Lordship may kindly list this matter next week as currently.
Mr. Lima, what is this case about?
Here the petitioner is seeking for review of the order passed in WBC number 123 of 2009.
And which court has passed that order?
Justice, sir.
And whether this court is competent?
Since University Justice Sir has already retired, now any court can come. Is there-
Okay, there's a notification. There's a notification. Let's see the notification. Where the honorable. Okay. So what was the order passed?
Worship, here the order was, Worship, I filed a writ petition claiming for appointment on the basis of land ownership. This honorable court has directed the department to consider my case.
Okay.
Since at the time of pending of the writ petition, the department has produced a verification report submitted by the verification report conducted by the DC, the concerned DC of the district. On the basis of the report, the writ petition was allowed. In compliance with the order passed by this honorable court, I am now appointed.
Okay.
After the disposal of the writ petition, now you're coming with this review. He was not a party also. Worship, what happened was like this. Against the vacancy in question, the petitioner, the writ petitioner as well as the review petition, he submitted your candidatures claiming for appointment on the basis of land ownership. Both our applications was forwarded to the state government. The state government,
Even the petitioners,
even the petitioner as well as the review petitioner's application was forwarded to the state government.
or even the review petitioner.
Yes, even this application. However, the state government conveyed its approval in respect of another person. Approval for appointment to the vacant post.
Okay.
So I challenged them. He remained silent. So after the disposal of my writ petition, now is coming.
Yes.
So on facts as well as in law, this review petition is not maintained.
Yes, ma'am. I had proposed to dismiss this review
Last
petition.
occasion also.
Even last occasion, you have no case.
He slept over the mirror for 3 years. After disposal of the writ petition is coming out with the review. Bishop, next Monday,
We. Okay, listed on
19.
19,
No.
listed on 26. No,
Bishop.
listed on 27.
Yes, Bishop. Please.
Listed on 27, 6, 2023.
Nice.
I'm happy, Lord.
Yes.
I'm on behalf of my senior merge and my principal.
Yes,
In this matter, the NI is yet to file their objection. The matter may come up in 2 weeks.
who are the parties?
Government and NI. That was from.
Yes, state. What is the case about?
Worship, state is not necessary, NIA is the main party, Lordship.
Who is for the NIA?
Sir and Miss. And Mr.
Where is he? You're for the petitioner.
Yes.
The case has been repeatedly adjourned on the ground that the NIA is taking steps to appoint its new council. So today, when the matter is listed, there is no representation on behalf of NIA. That is the respondent number 2. Stop. It is made clear that if on the next date, there is no representation on behalf of the respondent number 2, necessary orders will be passed, listed after 3 weeks.
Pleasure. May I please, my lord?
Yes,
Lordship, I order dated 14/12/2021 passed by this honorable court, your lordship's order. A direction was given to the respondents 3, 4, and 5 in the writ petition, my lord, to dispose of my representation by a speaking order within a period of 2 months. However, till then, my lord, my representation is yet to be disposed. The honorable court's order has been annexed at Annexure 1. The relevant portion is at page 10, my lord, of the contempt petition.
who are the respondents?
The respondents are the ENC, NPWD, the chief engineer, RNB, PWD, and the executive engineer, PWD, RNB, parent division. In the contempt petition, my lord. Because direction was specifically given to them in the writ petition, my lord.
1, 2, and 3. 1 is Engineer Limanaru,
Yes, my lord.
2 is Engineer Kaholi,
My lord.
3 is Engineer Kevide.
My lord.
What happens? They have all retired or what?
I believe respondent 2 has retired, lordship. As to the status of respondent 1, perhaps I have to take.
Yes, who is for the state respondents? Respondent number 1, Mr. Moaim Chen. Then what about the other respondents? Respondent, Mr. V. The respondent being government has retired. 1 and 2. Okay. So there's a respondent number 3. When was respondent number 3 impleted?
Lordship, respondent number 5 in the writ petition, my lord, the executive parent division, executive engineer parent division, my lord, PWD-RNP. He, my lord, is not much.
Who are the parties
The
in your
parties are-
contempt?
In my contempt, the engineer in chief and PWD
Yes,
and the chief engineer RNP.
yes.
Yes.
So why are you bringing executive engineer?
Respondents 1 and 2. Lordship.
Mr. Vijmomi, you are presenting
Lordship.
3.
2, Lordship.
And Mr. Ma, you are representing 1.
Your lordship, I filed, my count,
You file your affidavit?
yes, para 6. Para 6. Para 6 of my,
Yes. What is your para 6 rated?
para 6, your lordship, it is respectfully stated that the showing tribunal is diligently pursuing the matter in compliance with the direction of this honorable court. Order dated for 10/12/2021, passed in WBC number 338/2021. However, the competent authority for allotment of PIMS from BNR department. As such, the answering deponent is awaiting for response from BNR. Lordship, once a person has been given the appointment, the PIMS has to be, there is a department, the BNR department.
You have retired, but you have retired or you are still serving? You are for respondent number one,
Number one.
Engineer Limanaro. Are you still serving?
Retired.
You have retired.
But before the retirement, contract affidavit has been filed.
Whether notice has been served on respondent number three? By which order? By which order? Respondent number. Okay. Whether you have taken steps upon respondent number three, Mr. Sintianger. I don't see any order. Just wait, just keep this.
Lordship, in that case, it may be listed after a week, my lord.
Oh, you have not even issued notice. Heard, Mr. Santianger. The learned counsel for the petitioner. And Mr. Moemchin, the learned senior government advocate for the respondent number one. As well as Mr. Vij Momi, the learned government advocate for the respondent number two. Stop, although by the order dated 26/9/2022. Notice was issued, notice was directed to be issued on the newly implemented respondent number three.
Lordship, it is the newly implemented respondent number three who has filed the affidavit that the present counsel has just read out. I believe.
Mr. Ma, you have filed your affidavit for which respondent?
Respondent number one.
Respondent number one. Just see, just check up.
It is sworn by. My lord. It is sworn by one Tibetan Napro, lordship. I believe he is the new respondent.
So, Mr. Moore, you are appearing for which respondents?
Respondent number one, Your Worship.
One is not engineer KV Day.
No, yes, respondent number one was Lemanaro, now retired. Now retired.
Retired, retired, so what? Retired, but she still remains in the contempt.
Replaced by the,
Not replace, not replace. Not replace. Engineer KV Day is the new incumbent,
correct,
but in the contempt petition, this Limanaro cannot be replaced. Because every officer is answerable for the period he was in service, he or she was in service.
correct, correct, correct.
So there cannot be a question of replacement. The only question is implement as a respondent number 3.
Yes, yes. Worship, then employ this present.
Yeah, impleted already. Only your submission was confusing.
Lordship, in that way of the matter, Lordship, we may allow to make a certain correction in the affidavit, Lordship. Filed by respondent number 1.
See,
Make a.
Mr. Moa. In your affidavit, you had actually stated affidavit file on behalf of respondent number 1. But the engineer KV Day is respondent number 3. So that is where the confusion arises. Okay. Yes. There is one notification. Yes, there is one notification that if you have to make any correction, you will have to file one IA. You cannot just, we cannot just allow you to make correction now.
Yes. Aware of that, Worship.
So we'll give you time to make the correction, okay? So you are for respondent number 1 as well as respondent number 3. Limanaru and KVD. Correct.
Your Worship, allow me to file an IA since the latest.
Correct. Mr.
petition.
Ma Imchen. The learned counsel, learned government advocate for the respondent number 1 and 3 is allowed to file an IA, making necessary corrections in the cause title of the affidavit filed by the respondent number 1. Listed after 2 weeks. Okay.
Published, Worship.
Yes.
Published.
Deeply obliged, Lordship.
My pleasure, Lordship.
Yes.
I need to file the counter affidavit. So Lordship, we kindly grant some time to file the counter affidavit.
Okay. On behalf of the state respondents, ma'am, what is the case about?
Your Lordship, here, the petitioners are work charge employees
Ah,
who have been serving for more than 27 to 30 years. So they
Yes.
have been seeking this honorable court to grant them at least minimum scale of pay, your lordship.
Minimum scale of
Yes,
fee.
lordship.
Okay. MS Pichano, the learned government advocate. 6/4, 2 weeks' time. To file affidavit in opposition on behalf of the state respondents. Prayer is allowed, listed after 2 weeks.
Lodgement.
Your lordship.
Yes,
Lordship, by order dated 22/5/23, lordship, this honorable court has directed the state respondent to come up with an instruction, lordship,
22.
22/5/2023, lordship. However, lordship, till such date, lordship,
22,
I'm yet to receive instruction, lordship. So a week's time may be given, lordship,
22/5.
lordship.
About misutilization of his vehicle by some unscrupulous. Mr. So-and-so, learned counsel for the petitioner, and Mr. V. Jumami, the learned PP
Lordship.
for the state respondents. So by the order dated 22/5/2023, the learned PP was directed to place the report as to whether the seized vehicle in question is further required for the purpose of investigation in narcotics PS case number 08/2022. Stop. Today, when the matter is listed, Mr. V. Jumami, the learned PP, 6/4 some time
Lordship.
to comply with the order dated 22/5/2023. The learned PP is accordingly granted 2 weeks' time to comply with the state order. Listed after 2 weeks. Okay.
Please, my lord.
Yes.
Lordship, in compliance to this honorable court order dated 6/6/2023, the applicant approached the IO on 8/6/2023 and he gave his statements and he has been fully cooperating with the investigation thus far, Lordship. And the complainant also, Lordship, has withdrawn their FIR.
Okay.
That's the copy. The type copy is the next page, Lordship.
The withdrawal application could have been written in some better ways.
Yes, my lord.
The undersigned request for withdrawal of the same as the matter will be settled outside the Indian judicial system.
Yes, my lord.
Hmm.
This is the complainant.
Okay.
Yeah, yes, it's still letter.
So what do we do, Mr. Santi?
My lord, a case is pending before the Chief Judicial Magistrate Kohima. And unless there's a judicial order, the case cannot be
Correct.
closed just like that,
Oh,
Lordship.
okay.
Because the wheels of criminal law has already been set into
Correct,
motion.
correct. This is only for withdrawal
Yes, my lord.
and this has been filed before the judicial magistrate first class.
Yes, my lord.
So no order has been passed by the judicial magistrate.
No, not JMFC Lordship, the Chief Judicial Magistrate Kohima. CJM, my lord.
Chief CJM,
Yes, my lord,
Yeah,
my lord.
Okay.
We have also approached this honorable court by filing criminal petition 4 of 2023, praying for quashing of the FIR, Lordship. It is still pending, Lordship.
Okay.
So till that
So
is quashed-
so we make this absolute,
yes, my lord.
okay? Then we dispose of this application.
Lordship.
Okay. Mr. Veto, what is your the case diary? What does it say? Let me
They
just.
appear before the
They have appeared and then there is no requirement, further requirement. Have you typed it, the relevant portion?
no.
Have you typed?
No, sir. Since I received today.
You received? Today?
Lordship.
How can you say that? Last time also you said you had received.
But some of the page were missing, Lordship. Because of that, they have. The next
Oh,
last page.
uh, however, since arrest was not necessitated,
Lordship.
My lord.
that portion,
Yes.
they were allowed to leave only with a request to cooperate with the police investigation. You heard Mr. Santiago? The learned counsel for the
Applicant, my lord.
applicant. And Mr. Vijmo, the learned public prosecutor. By the order dated 6/6/2023, passed by this court. The learned public prosecutor was directed to produce the case diary. And the interim pre-arrest bail was granted to the applicant on certain conditions. Today, when the matter is listed, Mr. Vij Momi, the learned PP, has produced the case diary. Which has been perused by this court. In the case diary. Stop in the case diary. The IO of the case. Has stated that since the arrest was not necessitated the applicant was allowed to leave only with a request to cooperate with the police investigation. Mr. Sintianger, the learned counsel for the applicant, submits that the applicant has appeared before the IO of the case and is also complying with all the conditions passed by this court on 6/6/2023. Mr. Sintianger has also placed a copy of the letter dated 14/6/2023, written by the President NSF, that is the complainant.
My lord.
That is the complainant in the criminal case. Addressed to the Chief Judicial Magistrate, Kohima, Nagaland. Withdrawing the FIR dated, What is-
27,
withdrawing the FIR dated
27/5/2023, my lord.
27/5/2023.
2023.
On the basis of which complaint the applicant has approached before this court. The applicant has approached this court seeking for free arrest bail. After hearing the learned counsel for the parties and on perusal of the relevant records, this court is inclined to make the order dated 6/6/2023, granting ad interim bail, granting ad interim pre-arrest bail to the applicant, absolute, on the same terms and conditions, okay,
My lord.
as incorporated in the order dated 6/6/2023. The application accordingly stands disposed.
Deeply obliged. Lord.
Okay. The same order follows, Mr.
Yes,
Santry?
Lordship.
Same order follows till
27 lordship.
item 27. Okay,
My lord.
okay,
Deeply obliged.
yes. Is there? Oh,
The registry has not been done in the Assam.
this is 28. Yes, who is, this is, what is this? Is it the transport matter? What is this? What is the Asanla Wali? There is no representation on behalf of the petitioner. Continuously with effect from 18/7/2022. Stop the day when the matter is listed. There is no representation on behalf of the petitioner. List the case after 4 weeks. It is made clear that if on the next date the petitioner is not represented, necessary orders will be passed. Item. What is this, Ayu?
Please, Lordship. Lordship, this IA is for suspension. Filed under section 389, Lordship, for suspending the impugned judgment. Direct 27/10/22 and 10/11/22 for conviction of the present appellant, Lordship. To release the appellant during the pendency of this appeal, Lordship.
Yes, Mr. KV.
Lordship, service upon the respondent number 2, I don't know whether it's
Lordship, we received a call from the respondent number 2 that he has received the petition, Lordship. However, he's out of station, it seems, and so he has sought some.
In what capacity this respondent number 2 is a party?
Lordship is the informant, Lordship.
Is the
Informant, the complainant, Lordship. The police personnel, Lordship.
is it a suo motu complaint from the police?
Lordship.
You will be representing respondent number 2 also?
I can, but there's things, no instruction, Lordship.
You receive instructions on. Okay. Third MS Sensor,
Lordship, my humble prayer, Lordship.
learned counsel for the. We have considered you. Learned counsel for the applicant. And Mr. Kiangami, the learned public prosecutor. For the state respondents. On the next date, fixed. Mr. Kiangami shall come properly instructed on the case from the respondent number 2, listed after 2 weeks. Okay.
Muchas gracias.
None appears for the parties. Stop. The case has been adjourned time and again on the ground that the NIA is yet to appoint its counsel to prosecute the case. Listed after 3 weeks. Stop. It is made clear that on the next date fix, if there is no representation, the necessary orders will be passed. Yes,
May it please, Lordship. Lordship, this instant appeal is filed against the judgment and order dated 2019, Your Lordship. Your Lordship, this instant appeal,
who are the parties? Let's see first. Mr. Sharma, you are appearing for
I'm for a respondent claim, Your Lordship.
respondent number 1. Who is respondent number 2?
Lordship, respondent number 2 is the driver.
Then 3,
3 is the owner of the vehicle, Your Lordship.
whether notice
Service
complete,
extent didn't be served, Your Lordship.
by which order?
Your Lordship, upon the respondent number 2, that is a by order dated 10/8/2022. Upon the respondent number 2.
Have you submitted your affidavit?
Lordship,
When?
September, Your Lordship.
When? Where's the affidavit? Okay. This is in respect of respondent number 2.
2, Your Lordship.
What about 3?
3 already deemed to be served. Notice has not returned.
How can you say that?
So that's
Where is the order? Deemed served.
Lordship, I beg your apology. I've kept a particular order in other file and which I have not brought it. I beg your apology, Your Lordship.
This court has never passed that order which you are mentioning.
Your Lordship, then in that case, I may allow 1 week time to rectify the particular order. Your Lordship. Your Lordship, white order dated 10/8/2022. This honorable court was pleased to issue substitute notice upon the respondent number 2 only, Your Lordship.
Why from the very beginning, no respondent number 3? Only two. Mr. Sharma, there is no order for service of notice upon respondent number 3, right from the beginning. How this came to be listed for hearing? Wow. Where is Mr. Moajungla, Miss Moajungla? Order dated 33/20/22. 33/20/22. It says the respondent number 1 and 3 is duly represented by learned counsel, Mr. Imtiwapang and Miss Moajungla respectively. Therefore, no fresh notice need be issued to the said respondents. Was respondent number 3, Moajungla.
Your Lordship, since the Vagalandama has been filed, but it's not reflected in the course list.
It's not reflected in the course list. Which is this order? 32. Then Moajungla is not reflected. Okay. Yeah, Moajungla as well, because actually it is also reflected in this order. Moajungla for the respondent number 3. Okay. Okay. Mr. So-and-so, learned counsel for the appellant, and Mr. B.N. Sharma, the learned counsel for the claimant respondent number 1. Seven 22. By the order dated 6/7/2022. The appellant was directed to take steps for service of substitute notice upon the respondent number 2 by paper publication having wide publicity in the state of Assam and more particularly in the place where the respondent number 2 resides. Stop. This order, the order dated 6/7/2022 was reiterated by the order dated 10/8/2022. in compliance to the order dated 6/7/2022. The appellant has published the notice upon the respondent number 2 by substitute by publishing in the newspaper and has filed the affidavit dated 19/9/2022 to that effect. So the service upon respondent number 2 is therefore deemed complete. Today, when the matter is listed, none appears for the respondent number 3. The matter is accordingly adjourned to 2. The matter is accordingly adjourned to 2 weeks. Stop. The registry shall show the name of MS Mua Jungla. MS Mua Jungla. Kuma Aketoli J. Yeptomi. Kuma Setalo Sworo. Kuma Yang Pila Anar. And 2-year Krulhe Lohe as the learned counsel for the respondent number 3 in the daily course list, listed after 2 weeks.
Lordship, it may be on 18 July,
Listed
after
on,
vacation,
listed on,
18 July.
okay, listed on 18/7/2023.
Lordship.
God bless you.
Okay. Yes, of course. Let's see. This. This for the other side. What the parties?
Lordship.
Mr. Tongpok, you are for the claimant respondents.
Yes.
Then this our Baptist Mongdang.
My lord, I'm appearing for the Baptist Montang.
Okay, and what about driver Lano? Whether notice complete? Mr. Devnath, whether notice complete?
Lordship.
Because I believe this respondent number 4 is the driver of respondent number 3.
Lordship.
So this. Whether respondent number notice upon respondent number 4 complete?
Lordship, we've taken steps, Lordship.
You have taken steps. Let us see. Respondent number.
Even the substitute means, Lordship.
Pardon?
Even by substitute means also, through paper publication, Lordship.
To paper, okay. By which order?
Lordship,
Let us be very clear.
more precisely, Lordship, order dated 7/10/2021.
7/10 to, yes.
Justice Sertus order.
Published under these two local papers, yes. Whether any order passed? Deemed complete.
Lordship, no order is.
Respondent number 4. Respondent number 4. Yes,
Lordship, it is ordered as appeal admitted, fixed for hearing.
yes, see 1/4/2022.
Lordship.
Accordingly, service upon respondent number 4 is completed. Okay. What is the case about? What is your challenge?
Lordship, there are several grounds, Lordship.
No, what is what is the impugn order is?
Impugn order dated, Lordship, 17/7/2019, Lordship.
17/7/2019, which page?
Lordship, appears at page number 22 to 27 in my appeal memo, Lordship.
22.
22, Lordship. Annexure 2, Lordship, of my appeal memo.
Was it not page 13?
Lordship, it is page 22, Lordship. Page 13 is.
Oh,
Page 13 is the judgment and order of this Honorable High Court, Lordship.
where is that order? Of the tribunal?
Lordship, annexure 2, page 22 of my appeal memo, Lordship.
Okay. Mogul Control. Yes, what is the factum of the case?
Lordship, here,
Just give me a gist.
Lordship. The respondents is claiming filed a claim case before the learned tribunal motion for the compensation of the death of the deceased that in the alleged accident, Lordship. However, Lordship, in the instant claim case, Lordship, the road traffic accident which took place on 9/4/2015.
9/4/2015, and the petition was filed?
Lordship,
Okay, okay.
the
9/4/2015.
Lordship. The GD entry, it was entered after a delay of 6 months. However, there was no explanation of such delay by the claimant, Lordship. And the claim case was filed under section 166 of
What is the finding of the tribunal in that regard?
Lordship.
In regard to the late filing of the GD?
Lordship, earlier when the award was passed, Lordship, there was no such finding. However, after. There was no such finding from the.
Please bring this.
There was no such finding from the learned tribunal, Lordship. However, after the appellant insurance company has preferred appeal before this honorable court on being satisfied has remanded the case back to the tribunal for de novo trial.
On what ground?
Lordship, if I may be allowed to take your Lordship to.
Just give me the gist first. I will hear you everything, but give me the gist. Let me understand the case.
Lordship, it is at page number 20, Lordship.
Give me the gist first.
Lordship. Accordingly, in view of the reasons stated above, the impugned judgment and award dated 13/2/2018 passed by the learned MSCT Mokshan in MSC case number 24 of 2015 is hereby set aside. Case is remanded back to the tribunal Mokshan to decide the matter afresh after allowing the appellant to contest the claim on all grounds. Consequently, the learned tribunal Mokshan shall allow the appellant's application under section 170 of the MV Act as the written statement allegedly filed on behalf of the owner of the vehicle has not been accepted by this court to be a written statement of the owner of the vehicle and thus cannot be accepted as a challenge to the claim petition on proper grounds. Further, the claim petition has not been challenged in any manner by the said written statement. The amount already received by the claimant will be subject to the outcome of the fresh decision to be taken by the learned tribunal Mokshan, who shall allow the appellant to file additional written statement and take evidence if necessary.
Okay. So what was one of your ground was that actually there is delay in filing the GD.
Yes, FIR. There was delay in filing.
So whether actually the tribunal has actually adjudicated on this issue.
Lordship, after the case was remanded back, the claimant for improving their case, they have adduced three claimant witnesses, Lordship. That is the IO of the case, the doctor, as well as the deceased father, the claimant himself, Lordship. There are several grounds, and Lordship, as regards to the quantum, Lordship, the learned tribunal has awarded earlier has awarded an amount of rupees 19,27,300. However, there was no new papers available on record to enhance the compensation. However, the learned tribunal has gone with the same documents and has enhanced the award, Lordship. Even there was some ambiguity with regard to the multiplier as well as the rate of interest. It is not as per the law of the
Whether the tribunal has the power to enhance the award.
Lordship, there was no material documents available on the record to enhance the award, Lordship.
The law itself is very clear. To award just compensation.
Lordship.
And if the tribunal finds that actually enhancement by 2 lakhs, so it's just compensation then? Okay, you submit, you let us see, you submit.
Lordship.
You submit, let us see, what are your grounds? Submit.
Lordship. May I take a Lordship to my to the grounds of the appeal, Lordship? Page 5, Lordship. Ground number 2, Lordship. It says about the delay in filing FIR, Lordship. Lordship, the road traffic accident occurred on 7/10/2015. However, the GD entry says that it was lodged on 9/4. Sorry, the accident occurred on 9/4/2015, and the GD entry was made on 7/10/2015. Lordship. And there was no whisper of delay of 6 months, Lordship. However, the learned tribunal has rendered the impugned judgment without considering the this legal aspect, Lordship. Now, Lordship, the next ground is the police report, which is exhibited by the claimant as exhibit P1, Lordship. The police report has not been exhibited by the author of the document, that is the IO, Lordship. And the law is very clear to this aspect. Law is very clear to this aspect that even if a document is
What is the finding of the court below in regard to ground 2?
Lordship, in regard to ground two, Lordship, the claimant has, for improving their case, they have,
Forget about the improvement. Forget about the improvement. What is the finding of the tribunal?
The learned tribunal was satisfied, on the, grounds of, delay. as
Okay,
explained by the-
excuse me for 2 minutes. Yes, what is the finding of the tribunal in ground two?
Lordship, the tribunal, was satisfied on the explanation given by the claimant for the delay.
Where is that?
Lordship, it is appearing at internal page number 23, Lordship. Issue number 1
Issue.
of my appeal. Lordship.
Page 23.
Internal page 23. May I read, Lordship?
Issue number 1.
Issue number 1, Lordship.
Yes.
Lordship. In order to decide the above issue, I have to rely on the evidence adduced by the investigating officer, as well as the claimant and other circumstantial evidence. On evidence, the claimant adduced that my son died in a vehicular accident on 9/4/2015. He was knocked down by a vehicle bearing number so and so. The matter was compromised between the parties. As such, no FIR was lodged. I was not aware of the provision for motor accident compensation. It was on the first part of October 2015. Some legal experts approached me for filing compensation case. Therefore, we approached OC PS Changtongya for getting registered this accident case. I have submitted written complaint in this regard. On the other hand, I have examined the statement adduced by the investigating officer. He stated that on 7/10/2015, a written complaint was received from one Watikaba, brother of late Imti Younger. On receiving the said information, I, along with some other constables, made a primary inquiry at the place of accident, that is Longpangtong Ward NH2, Changtongya. I have interrogated some individuals who happened to be on the spot and eyewitness of the accident. Further, he continued that on the basis of the investigation and interrogation, it was ascertained that on 9/4/2015 at about 6:30 PM, a vehicle bearing number so and so driven by one Lanukab knocked down the deceased Imti Younger, as a result of which he sustained serious injury to his person and succumbed to his injury on the same day of accident. On cross-examination, these evidences were not shaken. Lordship,
Let us see your cross-examination. Take me to your cross-examination. Where is your cross-examination?
Lordship, it is here, Lordship. May I read, Lordship?
Yes, Clement,
Claimant, Lordship. PW1, Omenchiba.
PW1.
Father of the deceased.
Why these are not actually converted into type copies? Yes, read.
Cross, Lordship. It is correct to say that I am the claimant of this case and the father of the deceased, Imti Younger. It is correct to say that we have lodged written complaint in police station Changtongya Mokchong against the offending vehicle number so and so, and police have made necessary investigation in regard to this case of accident. It is correct to say that my deceased son was knocked down when he was on roadside near Longchangya Ward, and vehicle was driven in rash and negligent manner by the driver. It is also correct to say that driver could not control the speed due to rash and negligent driving. I admit the fact that the deceased son was regular government servant in government higher secondary, government high school, Mokchung, and was serving as a helper of carpenter with monthly salary of rupees 21,870. It is correct to say that his date of birth was 9/2/1979. This much, Lordship. Now, Lordship, his father,
This crosses by. This crosses by. How do I understand? This cross is by, it is just marked 3 cross.
Lordship, even. I'm also not the principal counsel in the trial stage, Lordship. I received the papers,
No. This cannot, because we don't know whose cross is this.
Lordship.
Then who is the tribunal? This is not the job of a high court to actually examine who has actually given that cross, who has not given that statement in cross examination, who has not given. Yes, Mr. Tompok, have you seen the record? How do this court ascertain?
Reports. I have only the photocopy of the form for recording deposition. It is handwritten.
And crosses by whom?
By no signature, is there only the signature of the witness is to be found.
This is by, and this is by our former justice, Hukato.
Yes,
Lordship.
but obviously it has to be the company's counsel who cross-examined the witness.
Without that definiteness, how can the court say that it is the insurance company who has cross-examined and the statement is reproduced?
In the
Something has to be
judgment,
done with this. What is the best way to correct this?
Mr. Edison Matai is the advocate, your lordship,
At
It is,
in the tribunal.
in the tribunal, your lordship. In the judgment and order, it is reflected.
Now, how do we make this correction? We don't know who has cross-examined whom. Yeah. At least get the necessary information as to the person who has met this deposition in the cross examination.
Lordship.
Without knowing, how do we just proceed? Correct.
Lordship, the best person, the counsel at the trial stage, Lordship, will be the best person to clarify this on the board, Lordship. As regard to the process of the claim.
The counsel means the counsel for the claimant as well as the counsel for the,
Insurer, Lordship.
yes, insurer.
Both the counsels, Lordship.
I think from this people, I think it has to be clarified.
Lordship.
Your lordship, since the record is not showing it, additional verification from the councils may not be
No, 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 no.
Appropriate, Your Lordship.
I am not going to put anything on record. But at least from your submission, I will be able to know. At least from your submission, I can
Yes.
record that.
From the judgment itself, Your Lordship, from the judgment and order, the counsels are recorded, Your Lordship. So from there only it can be determined. The judgment itself is here in the judgment first page. Annexure 2, page 22. Mr. Himan Rai is for claimant. Mr. Edison Maitai, advocate for insurer. Mr. Temjin Gaba, advocate
No,
for.
now I want to know whose cross-examination is this?
Lordship.
Whose cross-examination is this? There it is recorded,
Yes,
but there actually in the judgment, it has not been recorded that this is the cross-examination of the opposite party number 1, 2, or 3.
Your Lordship, in the signature, it is the claimant. The signature of the claimant is there. On the side, Your Lordship.
No, signature of the claimant. This is the cross-examination of the claimant. That is
Yes.
understood. Who has cross-examined?
That has to be ascertained. Lordship.
Whether the insurance opposite party number 1, 2, who has cross-examined? And normally, I think even all this recording is very casual. If not, actually, there is a form
Yes,
cross-examination of
Your
so and so person.
Lordship, yes, it is the tribunal where all this has happened. So now the tribunal itself has to verify this, Your Lordship.
No, now we cannot tell there's a tribunal to come and to do anything with this. Because his job is over.
Lordship, then in that case, if it may be assumed that since the company has been.
That's
company
why
has been
I want to
represented,
assume on the basis of your submission. So get it corrected and come.
Lordship.
Your Lordship.
Because I want to assume that on the basis of your submission, since now actually we do not know who has actually,
Lordship.
like whose statement has been taken in this cross-examination.
And who has performed the cross-examination?
Yes. So from your statements or from your submission itself. Because this code, so moto, I cannot say that this is the cross-examination of the opposite party number 1, opposite party number 2, opposite party. The cross-examination was done by which opposite party?
Opposite party.
You got me, no? You got
Lordship,
me.
Lordship, Lordship.
Because actually we don't know. This is the cross-examination of the complaint of the claimant.
Yes,
Who has cross-examined? That is the issue. Who has cross-examined? Because there is nothing on record to show.
yes.
Who is that person who has cross-examined? And on behalf of which opposite party the claimant was cross-examined?
Your Lordship.
So these things I think I should know at least.
Lordship.
And even if there is nothing on record, at least from your submission,
Lordship.
I will record that. This is very casual, too casual, too casual. Mr. V. Debnath, learning counsel for the appellant, and Mr. Tongpok Pongner, the learning counsel for the respondent number
1 and 2.
1 and 2. Stop, also heard Mr. So-and-so, the learned counsel for the respondent number 3. the case was taken up for hearing today. Stop. However, this court desires that more clarity is forthcoming. As to which of the opposite parties in the claim petition has cross-examined the claimant. So there is no clarity. On the depositions recorded by the tribunal. On the next date fixed, the learned counsel for the parties are requested to come with more clarity. As to which of the opposite parties in the claim petition had cross-examined the claimant. Listed after a week. After a week? After a week? Yes, listed after a week. Please come, please come prepared with all those information, because at least to apprise this court as to which of the parties had actually cross-examined the claimants, because there is nothing on record. Okay, we know that the claimant has been cross-examined.
Yes.
But who has cross-examined? That is not there. Yes, ma'am.
May I please, your lordship?
Yes.
Lordship, I'm appearing on behalf of my senior, Mr. Gauhati. Lordship, on the consensus of both the parties, I pray that your lordship may kindly list this matter on 18th July.
18th of July. Okay. The learned counsel for the parties submits that the matter may be listed on 18/7/2022. Listed accordingly. Okay.
Computer section court masjid. Court to over.